unique voice compared to others at the symposium. He is coming as a legal voice, a legal expert. I'll let you talk more about what it is you represent. But I found, when I first met him and heard some of his stories, found it fascinating. I said, you know what? A lot of engineering students that I work with have no idea about this side of business. So please enlighten us. Thank you.
Thank you. Julia hit the nail on the head. I'm going to offer a little different perspective on what this is all for. I'm kind of someone to talk about what happens when everything goes awry. So there are certainly much brighter technical minds in the room than myself, and I'll probably spew a few buzzwords at you, just things I picked up along the way. But you know, to start, I can't help but thinking that I'm a lawyer. That's what I do. I'm not a cybersecurity guy. I litigated complex cases at federal and state levels for about 10 years. And my rule was always, I want opposing counsel to call their best witnesses right after lunch when everybody's full and tired and not paying attention. So I hope that doesn't happen to me today. I'll try to be as empathetic as possible. But, so I work for a firm called PCI. We are a full service firm. We have about 300 lawyers. Our biggest brick and mortar offices are in New York City, Atlanta, and now London. I am part of a small practice group of about 9 lawyers, and we are what we call Incident Response Counsel. So what we do is we specialize in helping businesses, nonprofit, profit businesses, all shapes and sizes, respond to data security incidents, right? 99 out of 100, that comes in the form of a business email compromise, or it comes in the form of ransom. Once in a while, you have a rogue employee, you have an incidental disclosure, any lost flash drive, and anything that could constitute unauthorized access to data. Right? So they take all shapes and sizes. You know, the responses, no two are the same. I always like to say they're like a fingerprint. They all have something in common. They all have certain characteristics that can distinguish one from any of them. Right? So my team comes in. Typically, we get a call from an insurer. We're panel counsel. So most of the time, an entity or a company or an organization would call their cybersecurity insurance or cyber policy holder, say, hey, we got to work today and all our user endpoints are encrypted. They're asking for 50 Bitcoin wired to a random Bitcoin wallet, probably tracked somewhere in history. And so the insurance company then calls us. We are panel counsel. As most of you know, cybersecurity, in a very real way, is in its infancy stages compared to most things in world and in law, right? I think incident response has been around only as long as the internet is. Was that like 25 years maybe? 2001, I think, is when the World Wide Web got prominent. So, nonetheless, what I see along the way are a lot of things that happen that companies ultimately suffer from, because the nuanced and niche nature of this really, it puts people at a disadvantage, companies at a disadvantage, because they don't know what they should be doing before this happens. And the time to learn what you should have done is not after you should have done it, right? We don't want to learn that we need an homeowner's insurance while our house is on fire, right? So, you know, a lot of the things, and jump in with questions along the way. You know, I'd like for this to be interactive, but I'm going to itemize some of the things that we noticed, and we call them wartime and peacetime, right? Peacetime. What do you do before an incident so that if an incident occurs, it's not a breach. It's never a breach until your lawyers tell you it's a breach. I cannot stress that enough. You did not have a breach, you had an incident. Peacetime, pre-incident. And let's be real, it's not if, it's when. I don't care who you are, I don't care how sophisticated your cybersecurity posture is, it's when. Something is going to happen. Peacetime. What should we have done prior to? Uh-oh, something happened, we're at war. Somewhere in the country or the globe, more likely, is a threat actor, we call them threat actors, fancy word for hacker, is a threat actor who has somehow compromised a digital network, a digital environment of a company, and tried to exfiltrate data, tried to synchronize an email account. Now we're at, quote, war, right? What do we do when this happens? So I think I saw someone, is there anyone from Verizon here? Saw a name tag, okay. Somebody representing your company, raise your hand. Sir. Who are you with?
I have, I'm mostly a professor at Ohio State, but I also have a nonprofit that does public awareness campaign.
Perfect. One of your employees gets to work, their system is encrypted, there's a killing ransomware note on it, send us 20 Bitcoin, we'll let you back in and send you encryption. Who do they call?
Me,
How do they know that?
because I'm the only other person, but.
Okay,
But yeah, we don't have an incident response plan.
there it is, look.
That's true.
Led me right into that. Incident response plan, we call that. It's a very, very comprehensive document. It's gonna have a lot of complications in it, depending on the size and complexity of your industry, or it could be fairly straightforward. Nonetheless, the time to know what you're doing when the house catches fire is not after it's been burning for 20 minutes, right? So, gentleman Tony that spoke this morning, very impressive, by the way. I saw some things on there. He mentioned we do security operations center, and we do automated responses to threat detections. I assume probably through EDR software or services. Quarantine the environment, spot on, right? Call your lawyer. Please call your lawyers. Please call your lawyers. Automated response to the PR firm. And I'll tell you, if I've been up since 4:30 this morning, if I was still tired, that woke me up and gave me a nightmare simultaneously. I'm not here to give legal advice. What I will tell you is factually, if you build an automated response, that's a third-party communication into your response plan, or ask your security provider to do that, that is what we call discovery. That is a communication about the complexities of this intrusion, which we don't even know yet, because none of your stakeholders have been advised, because this happened at 3 in the morning when someone in Ukraine is wide awake, in a different time zone, and got in through a vulnerability in your firewall, in your VPN, or one of your employees clicked efficiently, whatever happened, you're now communicating to an outside organization. We have a problem we've discovered. Discovery dates are critical here. They can be very damaging to you if you don't frame them correctly. We have, don't use the B word, but in that case, I wouldn't be surprised to see the B word improperly. We had a breach, right? So you've now told a PR firm you had a breach. Starts a lot of different clocks for compliance measures that have to be taken for state and federal law. I see the gentleman nodding his head. I heard you say you were with Booz Allen Hamilton earlier. I know you know the trick. I've got 4 active matters right now with you guys as the DFI. So that's, yes, sir.
So what about your service providers that you have like on site managing systems?
Are you asking your third party or your internal people?
These are like Accenture or Booz Allen Hamilton or others doing parts of your operations. Can you communicate to them, or does that make that communication discovered?
That communication is going to be discovered. We're going to tell them as little as we possibly can while we equip them to speak to the lawyers and the DFI, Digital Forensic Investigation Response Firm. What I'm going to do as your lawyer, I am going to come in and I'm going to say, thank you, Accenture, Booz Allen Hamilton, whoever your MSSP is, Tony's company. We appreciate everything you've done. I'm going to need you on these scoping calls, and then I'm going to sign a contract with, I'm just picking a random one. I have no preference one way or the other. Surefire side. We're going to come, we're going to bring them in. They're the hired gun, right? They're going to do a forensic investigation. You don't hire Surefire. Your lawyer hires Surefire. That's because they're now an expert witness. They're an extension of your legal representation. You know what that means? It means everything that's said is privileged, right? So we want Tony, we want the gentleman with Booz Allen to be able to communicate with them. Tony can still be deposed, don't get me wrong. We get them the information, then the communications flow through your lawyer. Right? If that were in your incident response plan, you wouldn't have had to ask me just now. No, right? So everyone from level 1 to the C-suite should know what their role is when it hits the fan. Verbally speaking, sir.
When cyber insurance is involved and the insurance company has DFIR providers there, does the lawyer then reach out to the insurance provider as part of that loop to maintain attorney-client privilege as well?
Have you done this before?
Maybe.
Yeah. Close, right? Again, the flow of communication can vary a little bit in every instance, but The complexities of the policy are gonna have a lot to do with
Okay.
it, right? Sometimes the insurance companies will come to us and they'll say, we have a massive ransomware, such and such medical network appears to have 7 terabytes of data, what we think extra trading. That's all speculation. By the way, so-and-so is on this thread, they're gonna be the DFIR. Problem. More than likely, the insurance company has a clause in the policy that says, you're hiring your lawyer, you're hiring your DFIR. Okay. The reason for that, the insurance company has a very vested interest in making sure this gets handled correctly, or they're gonna be writing a much bigger check. Most companies, you know, notwithstanding your Fortune 500, your larger big companies, more sophisticated companies, most companies don't know what to do in this situation. They don't know what incident response law looks like. Most people don't even understand ransomware could lead to notification requirements, regulatory requirements, right? Are you a covered entity for HIPAA? Great. Now we have an OCR, Office of Civil Rights problem. We have notifications to go out for health insurance portability and accountability act. Are you publicly traded? Now I have to deal with the SEC on your behalf. We have to do an AK analysis. Is the scope of the intrusion or incident? It's not a breach. It's never a breach till your lawyer tells you it's a breach. I cannot say that enough. Is it such that an investor's decision would be materially affected? I don't know what that means. I'm gonna be honest with you. I don't know what it means, but I'd rather decide than the client decides, right? Are you a bank? Are you a stockbroker? Great. Now I have to deal with FinCEN and FINRA. Various complexities, various moving parts. No two are the same. But knowing who I have to deal with beforehand, knowing who's going to make the calls and the communications beforehand, makes it a whole lot better once it has to happen, right? Any sports fans in the room? Come on, you guys go to Ohio State, right? How many times do you think that play has been run in practice before you see it run on a Saturday? Right? What do you think the play looks like if it's run for the first time on Saturday? Right, it looks like a turnover, right? It looks like a blunder. How many times, sir, I'm gonna come back to you. How many times are your backups tested?
Me?
Yeah.
We were doing.
Okay, you do failover testing and whatnot on them as well?
Yeah, and we had moved to disk with protections to prevent overwriting.
Perfect. So you know where your backups are, you know what portions of the backups map to which company data, and you know how to employ them should you need to stand back up from backups.
Yes.
Music to my ears, Lee. I cannot tell you how many companies suffer substantial losses because they have backups and haven't tested it, they haven't run through. If you're losing 20 grand a day, 3 extra days is 60K. And I got news for you, odds are you have a hefty insurance deductible too. These things cost a lot of money, they can be saved, run the exercises, right? Run the exercises.
Does the discoverability part change in public sector?
Rules of evidence apply equally across the board. Mitigation may apply differently for a nonprofit than for a for-profit entity.
I'm talking about state government.
Say.
No, you're probably worse because you're FOIA, right? You, for the most part, if you're a government entity, you're subject to freedom of information. I can get your stuff right now. I don't even need it.
Up to a certain point, right? Because there's a conclusion spur. Yeah.
Once the lawsuit's filed, I have as much access to your stuff as I do to anybody else. Right? Or do you want to pay your lawyer $700 an hour to fight me on it? That's fine too. I mean, it's coming out of your pocket, right?
Well, it's coming out of the public's pocket.
It's coming out of someone's pocket, right? That's the point, right? Another thing I see a lot, yes, sir.
So you were mentioning earlier about people knowing that they're legal and, right, they go to legal. It's interesting to teach, and one of the things I say is in security, you never say the B word. We just don't say it.
I'm in.
We say incidents and then it gets.
Occurrence, event,
But-
incident, you didn't have to breach.
But it's also that, like a lot of end users, we don't train them that they should be, talk to lawyer, talk to. They know something has gone sideways, doesn't look right, they see it as an event. They contact maybe the help desk, and the help desk bubbles it to security, and then it bubbles to there. So a lot of times they won't know the legal, they won't know any process.
Listen, if the person that answers your phones, calls your help desk and says, I think we have a breach, I'm not gonna have a heart attack over it, right? It's incidental, right? Should every employee be trained to just say, hey, if you have a problem, turn it over to the help desk, no further communications? Easy solution, right? Plead what I would call the digital fifth, right? That's it. Just that's where communication stops. Then we go to the IR plan, we see who is our one or small nucleus of people we have making outbound communications, rather than the security operations center sending an automated notice to a PR firm. Oh speak British. Your lawyers are going to draft a comprehensive set of talking points, media holding statements, internal holding statements, stakeholder notices, preliminary notices, right? We don't know what's going on well enough to start to discuss it. And almost worse than being premature is reading wrong. We don't know. We don't want to jeopardize accuracy for the sake of speed. We appreciate your patience while we navigate this matter. Please bear with us. The security of your data is of utmost importance and we value your relationship. Right there. That sentence right there might have just saved you $100,000. Nope, we go to the PR firm, now we have a discoverable statement. They knew they had a breach. They thought they had a breach. Nobody's been notified. Some class action lawyer troll somewhere is gonna see this get posted on OCR's website and go, wait, you guys knew on September 26th. Look, you told your PR firm. By the way, you're telling your PR firm before you tell the impacted people? Do you really care? Of course you do. But you hear how I just said it? Somewhere there's some slimy lawyer just like me on the other side of the aisle. Of course, speaking a bit of jest. But these are the things that can be simply employed that kill confidence. The other one, and this is tough because again, it's 3 steps removed from the nuances of the niche nature of this. My friend from Booz Out, I'm gonna pick on you.
Formerly Booz Out.
Formerly Booz Out. I feel like I'm picking a jury here, right? I used to do some litigating around the room a little bit. Did you ever do DFIR work?
No.
No.
No, I fear incident response. That's brutal work. It's brutal work.
You're not wrong.
I love the people who do it.
Thank you. Are you familiar with cyber insurance policies at all? Have you ever come across them?
Yes.
Have you ever seen one written in a way that makes sense to the layperson in terms of the digital language of what's covered?
No.
Oh. Yeah. I'll tell you guys a good story. We represented an insurance broker. Obviously, I don't name any names. The gentleman had an insurance brokerage. They wrote policies for about 40 different companies, 40 different insurance carriers, right? Some of those were health insurance. HIPAA. You're either a covered entity, probably not a covered entity, but you're a business associate. So now you have all the same HIPAA obligations because you funnel data or process data for businesses. Their MSSP gets breached because a former employee changed the MFA protocols, didn't fix them. So some threat actor comes into a remote desktop connection. I might butcher this a little bit. If I remember correctly, this is what happened. If I miss something, don't hate me or jump in and talk about a lawyer outside of that. But I think this is how it happened. They then tunneled into each of the MSSP's clients through the remote desktop protocol because they were able to access it because of the improper MFA. All right, so one of those clients is an insurance broker. No problem, I got insurance. I have $1 million policy. No big deal. It's a big deal, sir. Trust me, you're gonna find out in about a month. Yeah, terabyte of that, right? Okay. This is what is exfiltrated. This is what the DFIR comes in, right? They call the lawyers to do everything right. Call the lawyers, thank you for not making any statements. I draft all their communications for them, everything's going well. DFIR comes in, they conduct their forensic evaluation, it takes about 2-3 years, fairly complicated matter. And they say, hey, look, here's the digital evidence that shows what volume of data was exfiltrated by this threat actor. Okay, roughly a terabyte. I'm proud. The next step is to identify what was contained in that terabyte. So we can identify individuals whose PII, which every single state has a different definition of, thank you for that, that makes life easy. Or PHI, because you're a business associate, you're now subject to HIPAA requirements, which information that can be used to identify an individual. I don't know what the hell that means, right? That's fun. Information that can identify an individual. It's a good time. We got to find out who's in there, right? He said, no problem, I got insurance. Well, the insurance is structured in such a way that your lawyers are covered under one portion of the policy, your forensic investigation is covered under another portion of the policy, notifications are covered under another. Data mining goes in the notification part. 50, maybe 100, I can't remember, $50,000 or $100,000 sublimit on it. If you maintain a terabyte, multiple terabytes, whatever the next highest level of volume is of data, and you ever need to mine that, You're gonna sell a kidney to mine that if you only have 100,000 in coverage. So the data mining company comes back with like a 500 or 600,000, maybe even 7, I don't remember all the numbers specifically. Well, it basically puts the company under. Because they can't afford to mine it, they thought they had $1 million in coverage, but the coverage is structured in such a way that the different nuances of the cyber portion of this apply differently to the ways you have to respond to an incident. Nobody would have expected, I wouldn't have expected that, right? You probably went to a broker, he was a broker. And they wrote the policy through one of the people they write policies for, and you have $1 million in coverage. Please have your lawyers and your security people look at these policies so they can tell you what happens, what the policy actually covers, right? I've seen a lot of companies suffer, a lot of people put out of work because of damages and costs. Not because they weren't paying premiums, because the policy, was just improperly written. It wasn't written in a way that's conducive to the complexion of the company. Right, and these are just basic things. They're basic things. Do them from the outset. They will make life a whole lot easier when you experience some type of data incidents. Not a breach, not till your lawyer tells you it's a breach. Yeah, those are some of the main things. I think probably I'm coming up on my time. Any one of those categories in and of itself, I could talk for a year, right? But saying how to properly secure something or how to prepare for an incident, it's probably like trying to find the edge of the ocean. It's indefinite. You're never going to get to the point where we're perfectly say, oh, we've got it. But there are some things you can certainly do, which will have a tangible, meaningful impact on mitigation when this happens. Yeah, sorry.
Get a question.
Sir.
I've seen a number of small organizations in particular, so mid-size, smaller mid-size, that when they suspect something may have gone wrong, there may be an event that could lead to or could be associated with a breach. And I always say, we don't even like the word incident. Event. An event has happened. I've seen several times where they will want to reach out to a defer third party to help them figure out, to do the investigation, because they don't have the staff and have the expertise. Is that okay? Is it okay for them to not go through legal or insurance, bring in a third party just to help them triage and review their logs and make sense of something that's simply an event that they don't know what it is? Or should they already bring their lawyers in just in case?
That's good. Where?
I am, because I've seen this a number of times where they say, we need help.
It
Let's get a
depends what you
deeper.
mean by okay. If you're concerned enough to sound the alarm, be advised that if that does not flow through your legal counsel, everything that you say is now subject to litigation discovery. You're concerned you have an incident which could grow into a breach once you dive a little deeper into it. My God, please go through your lawyers. Let me sign up the DFIR because now the communications are privileged. The facts aren't privileged. Ultimately, what happened in your network is going to be discoverable. But the DFIR's investigations, facts as to when we knew it, what we decided we were going to focus on, the internal strategy discussions with the lawyer and DFIR, those go to the grave. So if you're saying, is it okay? Listen, everything, just like cybersecurity, it's accessibility versus security, right? There's a balance. I wouldn't do it, but I can't tell someone else not to do it. You want to save a few dollars on your lawyer? Save a few dollars.
And that's what it is, right? That's what it is. It's,
Yeah.
well, we gotta pay extra if we bring the lawyers in now. We have a low degree of worry about this, but they don't know until afterwards,
But
right?
if that investigation turns up something you don't want it to turn up, man, you're gonna wish you paid those lawyers.
Yep.
You know, sir.
If somebody's already got an IT managed service provider who's helping with this and doing some monitoring, that's already in place, well before
Sir.
any event happens. How do you protect client privilege in that
You don't.
instance? Okay, so
That's
that's all discoverable. and
That's an
nothing you can do
operational
about it.
employment of a third party vendor. However, we get on the phone, I get your MSP on the phone, they turn everything admin credentials, they grant, email admin credentials, they grant access, we image every drive that needs to be imaged, we send it to DFIR.
So that's where you separate DFIR from your MSP. They just,
Spot.
step
I
out.
want the MSP or MSSP to give enough information to the DFIR to allow them to effectively do their job. Not a word more, stab. And, sometimes that people don't like that. You say, hey, we're smart too. I appreciate that you're smart. You wanna go be smarter than the witness stand? No, I don't want you to either. Be quiet and let the people who have privilege.
So to what extent have the state safe harbor laws been effective in protecting from at least litigation?
Litigation? None. Safe harbor laws will generally apply to notification requirements, regulatory sanctions, that type.
Okay.
Safe harbor, now, there are some states that will say such and such nature of a breach does not give rise to a private cause of action.
Yeah.
But if you house data for people who don't live in that state, let's say Ohio is one of those, I don't believe we are, but just hypothetically speaking, if we have safe harbor that says, hey, if Tony gives up Adam's social security number, Adam doesn't have a private right of action against us. Great, if Adam lives in Pennsylvania, I don't care what Ohio law says, I'm gonna sue you in federal court. I don't know a lot of business that only house data unique to one state residence. I can tell you 9 different matters I have right now where I have 50 states, DC, Puerto Rico, Guam, and one has Canada. So we have to reconcile all those laws. If someone thinks there's money in suing you, more importantly, if some lawyer thinks there's money in suing you because they posted on OCR, posted the breach results, 100,000 people got a notification in the mail, which you have to do, they're gonna sue you. They're gonna sue you. And then your coverage might turn on whether you took certain measures. If you have cybersecurity coverage, they will try to disclaim you as quick as possible if you don't do the things in the policy. Please know what the policy says. Please let your tech people and your lawyers do the policy. Save you a lot of heartache. All right, I think
All
that's
right,
it.
yeah, we're gonna cut for break. Adam will be here.